individual that need any help and support, whether they're living in the UK or they're outside the UK, then we can support them. So please spread the word, tell other people where they can get help, signpost them to our website, which is justiceforwindrushgenerations.co.uk. And I will tell you about the advocacy information, which is in the chat. So our advocacy is our partner organization. And again, doesn't matter of your location, where you are, the advocacy project and the workers there will be able to help you. So,
hi, Garrick.
It's now 7 minutes after 2. We're going to make a formal start now. So welcome.
Garrick, just a quick question, Garrick. So are you going to start with the scheme, or are we going to go straight into the
yeah, we're going to start with the scheme. We need to give people the background, and then we can pick up afterwards the other bit
then we'll go into
last week meeting. Yeah.
Okay, fair enough. Okay, no worries.
Yeah. Okay. So good afternoon, everyone, and welcome to Windrush Compensation Scheme Sunday Chat. If you're here for the first time, please mute your mic. And just mention the session will be recorded. So please keep your camera off if you so wish. You will get the opportunity to ask questions. And we will try to answer those questions to the best of our knowledge. If we're not able to answer your question directly, then we will come back to you with a response. The Sunday chat focused specifically on the Windrush compensation scheme. We don't deal with anything else. We focus on that scheme. And we help people, first of all, to understand the scheme, and then to see whether they're eligible to apply to the scheme. And that's quite important. So it's not an automatic right. You have to do some tests, some eligibility tests to see whether you're eligible or not. So we will go through that information. You may want to write things down for your own reference. So a pen and a paper would be useful. And we always encourage people to share the information from this platform with other friends and family members so that they can have access to this information also. I've just mentioned it's sponsored by Justice for Windrush Generation. You can find our web information, www.justiceforwindrushgenerations with a s.co.uk. There you will find our aim. You will also find who is eligible for the scheme. And then you will find information relating to different aspects of the scheme. For example, primary claimant, close family claim, and deceased estate. All that information is there in one place. All the information that we are using today and all of our events is in the public domain. We don't have any other information. It's in the public domain. So our reference point is .gov.uk/Windrush compensation scheme. There you will find direct information from the Home Office about the scheme and clarification of terminology, etc., etc. So that's where our information is coming from. We always make the point that we're not immigration advisors, so we do not give immigration advice. Windrush comes out of immigration legislation, so we can direct you to more specific immigration advice, and you can find that information on our website with different legal organization that specialize in immigration and other aspect of law. So to begin, let's assume that we don't know anything about Windrush. And the first thing we want to know is to understand what is Windrush and who make up the people that often referred to as Windrush generation and descendants. So just a bit of background. The timeline for Windrush generation and descendant started at 1948 with the first generation. And the timeline continued through the 40s, the 50s, the 60s, and the 70s, and into the 80s. So starting at 1948 up to 1989 is a Windrush timeline. So that would raise question that people who arrive after those dates are actually outside of the Windrush compensation scheme. So if you arrive in the UK, for example, 2001, then the Windrush compensation scheme is not be able to assist you. And we will explain why as we go through. The Home Office produced eligibility criteria about the scheme. We always make the point, the first thing one should do is to check if they're eligible. And that is about dates. That's about when the individual arrived and settled in the UK. And if they left and have not returned, or if they've left and returned at a later date, we still work on the basis as when they arrive and had settled the first time. So the first generation arrived 1948 and subsequent generation arrived continuously. And the Home Office is very specific around following the eligibility criteria. So they produce the information that will help us to identify if we are eligible. Now, one of the things that we always raise with people, the first thing that an individual should check is status. First step, look at your status. Have you got status? Did you have the status? Have you lost status? So status is the first thing. Now the compensation is a separate scheme. So we have status and we have compensation. And in order to get compensation, you have to check your status and be eligible for that status. Say, yes, I'm eligible. And the next question would be, did you suffer any losses or were you impacted? And if you were impacted because you could not show evidence of you have the right to be in the UK, you didn't have any papers, for example, then that would have meant you were impacted because you did not have the necessary document to show when it was required of you. And that is the bit of compensation. And we're going to explain the compensation bit. So, dates are important. And from a Commonwealth country, that would be yourself, your parent, or your grandparent. If you're from a Commonwealth country, you would need to arrive and settle in the UK by the 1st of January 1973. That's an important date. Either yourself, your parent, or your grandparent would need to be settled in the UK by that date, 1st of January 1973. That's the first thing. So you can put a tick to that if that applies to you and you say, yes, I was here at that particular time. The next group would be people from any other country. Notice the point, from any other country. They would need to be in the UK and settle by 1989. 1989. Now, so we have two dates to work with. We have 1973 from Commonwealth country, and we have 1989 from any other part of the world. There are those people who arrive in the UK on other family passport. They did not have any passport themselves. They arrive as children. So when the time came for them to actually apply for documentation, they experienced difficulty in applying and getting the documentation. And then the Home Office asking for a whole range of different information to establish whether or not they are eligible. Did they arrive at the right date? Can I mute that person? Who is that? Okay. Yeah. So two dates, 1973 from Commonwealth country, 1989 from the rest of the world. Very important date. So if it's yes to either of those, then you're eligible to apply to the scheme. However, you can apply to rectify your status to get your papers. And that's one scheme. And the second one is if you've been impacted over a period of time because you did not have necessary documentation, then that's the compensation element. There has been people who just apply to rectify their status and they were not impacted, so there's no compensation to be claimed. However, those who were impacted severely, then their compensation compensation to be claimed. And when we say impacted severely, I will give you an example of that. So, for example, you were working in an employment, could be national health, it could be other local authority, etc., public sector organization. And you've been there for 10, 15, maybe 20 years prior to 2012. And everything is fine, no problem. Go to work, you get your salary, everything is fine. But one day, the manager of the company asks you to bring your passport in because the Home Office had issued directive to employers to make checks as to who's working for them and do they have the right to work in the UK. Prior to that, it was no issue. But that came much later. So the employer would say to its employees, can you bring your passport in tomorrow? Now, of course, if you haven't got a passport, you've got no papers, then red flag immediately. So the employer would not be able to keep you on as an employee. You had to dismiss. By losing your job, you're immediately been impacted. You've suffered loss. By losing your job, you also lose the ability to access public fund from Social Security, from local authority housing, a whole range of services that you will not be able to access as a result of you losing your job because you did not have the documentation. In other words, now there's a blacklist against your name. Wherever you turn, you will not get any help because you've now been identified that you haven't got the right to work in the UK. So you cannot find employment. And that will impact not just on yourself, but your family, your children, etc., etc. That's just one example of how an individual would have been impacted and how from status to compensation, you see the difference. You did not have the documentation, you didn't have your status documentation, so you were impacted. And by being impacted, you now have lost a whole range of services and benefits. So as an individual, if that has happened to you and you are, as we said, your Windrush generation, because you already identify that you were here at the appropriate date from a Commonwealth country or from the rest of the world, then you will seek some help in order to make the necessary application to the scheme. And a lot of people, sometimes they know that they need to do something, but they're reluctant to do something about it. And there are many reasons why they may be reluctant to do something. First of all, they don't know where to go to get any help. They don't know who to trust. So they don't talk about it. And months become years and years become decades and so forth and so forth. Okay. So with the Windrush compensation scheme, we have different category of claim, an individual making a claim for themselves is known as the primary claimant. The primary claimant is the person who make the application for themselves. And the Home Office produce guidance for each of the claims. Guidance for primary claimant, guidance for close family claim, guidance for deceased estate claim. And it's very important that we consult and read the guidance so that we understand what is required in our application. It's no point trying to fill an application out without reading the guidance. And there are two sets of guidance. There are the general guidance, and there is a casework management guidance, which is a lot of pages. For a lot of people, they will look at the guidance for each of their claims. So they will look at the guidance for primary claimant, and it is 40 odd pages. They will look at the guidance for close family, 24 pages or so forth. Yeah. But the casework guidance is quite different. There is more information contained in the casework guidance. And the reason why we suggest people should read it and get familiar with it, and we're not suggesting you just sit and read it, that's it. You know, use it as a reference point. Go back to it each time. Here is on screen. Primary claimant form. Yeah. Primary claimant. So the reason why we mention the casework guidance, which is a lot of reading, it's because when you complete your application and send it into the Home Office caseworkers, that will be the guidance they're using to assess your application. So it makes sense, doesn't it, for you to know what is it they're looking for in your application. And you will understand the language that they use in the guidance and what they're expecting to see in your application form. There has been many cases where there has been no award and nil return because the information that was provided by the claimant was not sufficient for the caseworkers to approve an award. And so they return as a nil award. So looking at the casework guidance will help the claimant to understand what it is that they are expected to put on the form. When you answer those questions, it will tell you what you need to focus on. Very important. However, not everyone can read the casework guidance or any guidance for that matter and come to a reasonable understanding of what is required, because people have different abilities and people will have maybe a whole range of different circumstances that will impact on them reading themselves and completing the form. So we say to people, reach out for help. Reach out to somebody who can assist you and help you to complete the application form. And the person that will be assisting and helping you will be communicating with you and asking you questions for you to tell them your story. What has happened to you over the last 20, 30 years? Yeah, explain that to me. Tell me. And while the advocate will be talking with you and doing all of that, things that were buried in your mind 20, 30 years ago may spark and you remember certain situation that you had forgotten. But because someone is now talking with you about your situation, in other words, your journey, your story, you now remember certain things that you did not remember before. One example could be that you travel out of the UK several times, but when you were returning, you didn't understand why you were taken out of a line and questioned by immigration officers for 35, 40 minutes and then sent on your way. You didn't understand that. You just thought it was normal. Well, that happened to you several times. So that might have been 3 or 4 times over 25 years that happened. Again, by the advocate having the conversation, you will remember, yes, that did happen to me. You know, I didn't even remember about that. It comes back to mind. So please, reach out to someone, preferably someone with the experience. We always refer to advocacy, advocates who are there to help with the application, guide you through the application, because there will be people who just find it extremely difficult to do, how to begin to answer certain questions, because the guidance is asking you to be specific. And you just have to focus on that answer, that particular question. So I've just spoke about primary claimant making the claim for themselves, either them completing the application or somebody assisting to complete the application. That is the primary claimant. There's another claim, we call it the close family claim. And each of those claim, primary, close family, deceased, each of those, the eligibility criteria applies all through. So that would mean you arrive in the UK by 1973, or you arrive in the UK and settle by 1989. So each of those claims you would have to fulfill that eligibility criteria. However, when it comes to close family claim, what you do, you put down the primary claimant guidance, and then you focus on the guidance for close family claim. And we keep stressing this every time. Before you start to put anything on paper, read the guidance. Read the guidance over and over and over. And we also suggest you start with a draft. Those questions Do not enter the application, complete the application, do a draft on an A4 and work out the question and the answers, put it on a draft first. No different from doing your college work or university work, your exam. When we're doing essays, we draft a couple of drafts, maybe 2, 3 before we do our final. Because when you draft your responses, you're able to ask somebody to have a look at it. And while the person's having a look at it, maybe asking you some question that you've left things out that should be there. And that is the beauty of a second eye, as it were. Somebody that can prompt you and say, well, you said something here, but, and that but will give you a bit more information. So I'm going to ask Roland to just speak specifically on the close family claim. Right? And listen carefully. This is a claim that we're trying to get more people to make application. Close family claim, which involve more than 1 or 2 or 3 people. So please pay attention to the close family claim. Roland, can I bring you in, please?
Yes, you can. Good afternoon, everyone. Can you hear me okay?
Yeah.
Yeah, sorry, my voice a bit husky today. Okay, so Gary Cam outlined to you a bit of history about the Windrush generation and also went through eligibility criteria and the entitlement. Can you hear me okay, Gary?
Yes, I can. Yes.
Okay. So in order to be, I'll just go quick one over that. In order to be eligible to apply to the scheme, eligibility is who is allowed to apply to the scheme. You say it's about where from and timeline. Garrett mentioned 1973 from any Commonwealth country, 1989 from any country, including Commonwealth country, etc. That is the eligibility. Then entitlement, okay? Need to understand the difference between eligibility and entitlement. In order to be entitled to compensation, you would have had to have your life impacted or disrupted due to your inability to prove you've got a right to be meted. And there's work, loss of earnings, not being able to get student loans, student grants, using the doctor, the NHS, getting pension, and so on. And he mentioned 2 categories of claim out of the 3: deceased estate, primary deceased estate. There's no difference between a primary claim and a deceased estate claim, except that that individual that would have been eligible and entitled to compensation as a primary claimant is now deceased. And then thirdly, we've got close family member. You can apply as a close family member if you are lawfully in the UK at the time when the deceased and entitled individual or the primary claimant was impacted, you were lawfully in the UK at that time. Comes to the close family member claim, you do not necessarily need to come from a Commonwealth country in a particular timeline. You can come from anywhere in the world. And as I go along and explain the close family member category of the scheme, you will understand why. In order to be eligible to claim as a close family member, you need to fit into one of the following categories. It's not, you need to be a close family member of the primary claimant or the deceased individual. But when we say close family member, we're talking a particular set of family members, not a great-great-grandma or second cousin, third removed or whatever. It's the following group of close family members. It's as follows: wife or husband of the primary claimant or the deceased individual, parent of the primary claimant or deceased individual, children of siblings of, we're talking brothers and sisters here, stepchildren and step-parent of the primary claimant and the deceased, or the deceased individual. The step-parent and stepchildren, this only came about, I think, on the 23rd of April this year. So I'm not sure on the date, but it was in April 2024. Prior to that, stepchildren could not claim. Myself, Garrick, and others brought it to the attention of Home Office, and those changes were made. I'm not saying it's just down to justice for Windrush generation, but we've been going on about it for quite a while. And sixthly, anyone that lived in a relationship, so to speak, cohabiting with the primary claimant.
Increase your volume a little bit more, Roland. Just increase your volume, please.
Yeah, anyone that lived in the relationship or cohabiting with the primary claimant or the deceased individual for 2 years or more. You can hear me better now, Garrick?
Yeah, that's okay. Just keep that level so we don't lose anything.
Okay. Yeah. So there's no number there. They did not say 10 or 5 or 7 or 8 close family members. They said close family members within a particular group. And I gave you those groups. So we've got situations where you've got one primary claimant, and that primary claimant, due to that primary claimant being impacted and was made an award, offered an award, got 13 close family member claiming. Got the mother and father claiming, and the wife or husband claiming. An individual may have 5 or 6 or 8 children. All of those 8 children can claim. May have 5 siblings, 3 brothers, 4 brothers, whatever, sisters, whatever. Those can all claim. Why they can claim? And I need to dismiss a bit of a myth or misconception here, that the close family members that supported the primary claimant can make a claim. The close family members that supported the primary claimant can make a claim. That is incorrect. You do not need to have supported the primary claimant financially or any other way. You don't need to have supported. The claim that you are submitting as a primary claimant is down to your experience, due to how you were impacted. So you would have been impacted as a close family member of the primary claimant or the deceased individual. You were impacted emotionally, stress, anxiety, or you were inconvenienced due to what the primary claimant was experiencing, due to what you saw them going through. And I'm going to give an analogy. It's some a bit simplistic, but hopefully it will make the point. I used to use another analogy, but it was a bit triggering, so stop using that. Little child, girl, child riding on the road on a bicycle, nice warm sunny day, had an ice cream fell. Just at the point when the ice cream fell on the floor, the mother was at the bus stop. The father was there, sisters, brothers, etc. They saw what happened. Child was distraught, lost her ice cream. It wasn't the family members that were at the bus stop ice cream. They were not the one that impacted, but they saw what happened. And due to what they saw going on with that child being distraught, etc., they themselves had secondary impact. Okay? So back to the actual situation. You could have a situation where mother lost her home, she had children, had brothers and sisters, etc. Mother is distraught, came from Ghana when they were in the 60s, was working somewhere, was told to bring in documentation to prove she's got a right to leave the UK. Consequently, lost her job, lost her home, whole life is a wreck, she's crying, slipped into depression, etc., etc. Her children saw that, her brother saw it, wife, etc. Partner, etc., etc., saw that. As a result of that, they themselves can claim compensation as close family member. A lot of times, the assumption is made that the close family member claim is an inferior claim to the primary claim or deceased estate claim. That may not necessarily be the case. In many cases, you may find that the close family member claim or the close family member impact is more in-depth and more severe than the primary claimant. I'll give you an example. One particular individual was impacted for 3 months, came here in the 60s, lost her job, etc., was locked out of the UK. She used to support her daughter with daughter had a bit of a mental health issue, used to support the daughter. However, at the point the doctor needed that mother, the mother was exiled from the UK, locked outside the UK, which the home office admitted to. Daughter had a nervous breakdown, didn't get the support of her mother. Consequently, the daughter was impacted to the extent that the daughter ended in a mental institution. Children was taken away from the daughter, went into social service. One ended up somewhere in the Caribbean. The other one ended up somewhere else. Severe impact for that close family member. And the mother lost her home, etc., etc. The impact on life, level of compensation for both primary claim and across the board start the 5 levels. Level 1, 10,000, level 2, 20, level 3, 40, level 4, 70, and the level of 5 is 100,000 and above, depending on the level of impact. And average, what we're seeing at the moment, we do not necessarily agree with it. The average is usually 20,000 for close family member claims. If it's a situation where the impact lasted for a few weeks, we're talking about 10,000. Weeks turning into months, usually 20,000. If you're impacted to the extent as a close family member, you go and see doctor, your GP or your counselor, whatever, and say, doctor, counselor, mother is going through this, my husband is going through this situation. They are stressed, I am stressed. Went to see a doctor a number of times. However, you did not get any medication. We're talking about possibly a level 3 here, 40,000. Going to the doctor, went on medication, was on medication, then still on medication. Now, despite the fact is a number of years ago, 5, 6 years ago, but impacted to the extent that you get you were on medication, still is on medication, then possibly a level 4, 70,000. Yeah, were impacted to the extent that you were so stressed out, so depressed, you couldn't lose it. You couldn't go to work. You have to take time off work. Possibility that you could claim for loss of earnings. Just quickly before I wrap up, there are 2 elements to the impact on life. One is to the close family member claim. One, how you're impacted as a close family member, emotional stress, anxiety, inconvenience, etc., etc. And there's also living expenses. You supported this individual, this primary claimant, cut them emergency money money to go into emergency shelter, you buy them some food, they move into your house and you had to be washing the clothes, the gas bill went up, etc., etc. That is a living expenses. Element of it, they may have been stuck out in Sierra Leone for 6 months. You have to be sending them money through MoneyGram while they're on the street, etc., Western Union, etc., etc., to support them financially. So that is a living expenses element of it. The impact on life element is about how you, the individual, the sister, the brother of the primary claimant, etc., was impacted. I'm going to hand back to Garrick at this point. Skipped over the surface, so this. And just before I go, earlier I said there's no number, so you could have a numerous close family member claim. In addition to that, as a close family member, we have identified this on a number of occasions, you can submit more than one close family member claim. In a situation, let's say your deceased parents were both impacted, you, the daughter, can claim against the mother, one claim there against the mother, claim against the father, he too was impacted. Also, you identify that one of your brothers and sisters was threatened with deportation to be deported back to wherever, then you will have another claim there. And in addition to that, what you can find, let's say a mother was impacted, mother is still alive, son is still alive, mother was impacted, son was impacted. What you can find is that mother put in her primary claim, son put in his primary claim, mother claim against the son as a close family member, son claim against mother as a close family member. Those are actual situations, those are actual claims that I have worked on, okay? I'll hand back to you, Garrick, and
Thank you.
At this point,
Thank
I'll
you for that,
invite
Roland.
any question or elaboration, clarification, etc. Back to you, Garrick.
Okay, that's great. Thank you. So you've noticed there's quite a bit of information regarding the close family claim. I'm just going to break it down into bite size. And one very important thing to note, making a close family claim will not have any impact on the primary claimant payout award. It does not come from the money that will be allocated to the primary claimant claim. The close family claim would be a separate. Yeah. So don't be thinking if I put this claim in, I'm going to reduce what my father, my sister, my brother, my uncle will be getting. Has no impact at all. Separate. The other important thing to note, you must have a conversation with the primary claimant before you submit a close family claim, because there has to be some cross-reference somewhere. You're putting a close family claim for me and you've not spoke to me. So conversation needs to take place. And when the primary claimant receive a notification for an award, in other words, an offer is being made to the primary claimant, it's at that point that we will suggest the close family claim should go in. Notice what I've said. When the primary claimant receive an offer, whatever that is, then the close family claim should be submitted then, not before, right? Once the offer is made. You notice Roland mentioned specifically there are no numbers attached to close family claim. Some family have 10, 12, 13 children. Can you imagine the impact on the different family members? And what we say about this particular claim is that many people are not submitting close family claim, despite the fact that they've been supporting close family for many, many years. And we don't know whether they don't understand the claim or they need more help for somebody to assist them, but we're not seeing a lot of close family claim being submitted. So please, we want people to, address this issue. Ewan, please.
Hi, Garrett. Good afternoon. Thank you guys for having me. Just quickly, Roland said a lot of things and it makes sense, but I wanted to know if these things are highlighted or actually specifically mentioned on the Home Office website or on the application forms and guidance, or on the guidance, let me say, that these close family members and the types of impact, etc., can be made. I mean, how clear is that for a person making an application? That's what I wanted to ask.
Good point. I'm going to invite Ron in a minute, but let me just, I've got the casework guidance open, and this particular point around close family claim, paragraph 3.2, Annex B, fees and costs. Paragraph 3.8, Annex H, impact and life. This was the one that Roland was trying to focus on. Paragraph 3.9, Annex discretionary award. Paragraph 3.10, Annex J, living costs. This is the sort of information that we're encouraging people to actually read the caseworker's guidance. There's more information in the caseworker's guidance than just the close family claim, which is 24, 26 pages. A bit more information. Just before I bring Roland in, here's a point, 2.7a. A close family member who is in the United Kingdom at the time of making the claim must be lawfully in the United Kingdom, meaning of paragraph 2.9. And this is where we get some detail in the casework guidance to assist the claimant get the right understanding as to what they're looking for, to what point need to be addressed. And then, for the purpose of paragraph 2.5, a person is a close family member of a primary claimant if the person was at the material time. Notice the word used, at the material time. There's a bit more information there in the guidance that is going to help the individual close family claim better understanding. Whereas the general information, you may miss some important aspect of that. And then it goes on to say, for the purpose of paragraph 2.5, the claimant's spouse or civil partner and living with the claimant, the claimant partner living with the claimant, unmarried or not in a civil relationship, in a civil partnership, as a husband, a wife, or a civic partner for a continuous period which lasted in a total of 2 years or more. Okay? And this is the reason why we are emphasizing how important the casework guidance is for each of the claim: primary, close family, deceased. Far more information, better understanding of the question, and where the related answer is in the document. Roland, is there anything else you would like to say in addition to what you want to just ask?
Can you hear me okay?
Yes.
All right. Ewan, please ask the question again. Ask the question and elaborate, please.
Yeah. No.
I've got good reason to do that.
Yeah, I was just actually asking, you made some good points, and I was just asking if those are clearly defined in the guidance for claimants to follow and understand, the context in which they can make those sort of applications, and the extent to which they have suffered an impact. I just wanted to know how clear those were in the guidance. I don't normally deal with the compensation side, but in fact, I don't. So I just wanted to know, because I don't have much knowledge of that side.
Mm-hmm. Yeah, yes, it's there. But I think it would have been better if it can be better explained, and some examples as well. But yes, it's there now. It's made clear. In addition to that, a lot of times when they send out letters to primary claimant or applicants to the claimants of deceased estate, they do send with a one paragraph there encouraging to spread the word about the close family member category of the scheme. But yes, it's there. And just to mention, elaborate on something that Gary said earlier on. When it comes to close family member claim, it's very important that if possible, much as possible, share information among each other. In fact, not only close family member claim, even with the primary claim, because you'll find that the primary claimant or the deceased individual may have had an experience, or may have had many experiences that is not shared with other, let's say, the deceased individual had a number of children, a number of siblings. They may have shared information with others. Some children or some siblings that may not be shared with, or they may even invest more information in one particular close family member than the others, sometimes even friends. I usually say this: you find a lot of family many families, one particular individual that appoint themselves as the family's librarian, the family's accountant, etc., etc. And whenever you need documentation and information, you've got to go see that particular individual. And in many cases, they are very reluctant to give your grandma's birth certificate or whatever information they have. In this particular case, when it comes to the Windrush compensation scheme, that particular individual, that particular librarian is not only going to put the other close family members at a disadvantage, they're going to put themselves at a disadvantage as well. It's about information sharing as they go along. And I think in the chat, someone asked, once you claim the compensation, and I think they use another word, but I rather use compensation in this particular case. Will it be clawed back if you're on benefit? No, it should not be clawed back. Yeah, you're on Social Security, form of Social Security benefit, right? And I think the threshold is 16,000. After, then they start clawing back or assessing. Should you get 10,000 or 100,000 or whatever it is, 200,000, then it should not be taken into account that it's actually stipulated there. That does not mean if you are running a business and you hold the taxman some money, then they will not claim it back. I'm talking about assessing you for Social Security benefit. You know, a lot of misleading information out there. A lot of decisions are made based on assumption, what you believe or what you think. In this particular case, you've got to go definitive and make decision based on facts, not what you believe or some hearsay. A lot of what we're saying here is actually stipulated in the application guidance note for all three categories. But it goes further in the caseworker guidance, this 107-page document. That is the book of rules, so to speak, that the caseworkers, the decision makers, the people who are deciding whether or not you're entitled to compensation and how much compensation you should get. That's why in many cases, when we submit an application and a person is compensated at level 2, 20,000, we can go back to them and say, based on what is stipulated in the guidance note, we are of the belief that this particular individual should be a level 3 at 40, a level 4 at 70. And we basically open close quotation mark, copy directly from the guidance note and stick it there because we do understand what should be happening and the approach that should be taken and go definitive on that. So it's not down to what the caseworker feel or believe. It's what is stipulated in the guidance note, and they should be doing exactly what is said on the thing. And it's not being done at the level that and that's another discussion we're going to have later on anyway, and about changes to the scheme, etc. And we particularly blame the managers. The managers know exactly what should be done. They've got the guidance note, the same guidance note that we're reading. However, they're not following it as much as they should, despite whatever impression they may be parading around and giving at the moment. The managers within the care compensation scheme are not doing what they're supposed to do. They're still not compensating at the level that they should compensate it at, based on the guidance note. I know I went off a bit of a rant there, but it's warranted. Back to you, Gary.
Thank you for that. And this is why we keep emphasizing the reference point. I have in front of me the full guidance, and that's where you get more detail and even definition of what is meant by this term. But for other people, if they receive an award at what Roland just says, and it may be 20,000, they probably they wouldn't know what the caseworkers' guidance have to say, so they'll just accept whatever they've been offered. Okay? And this is why it's important to get the support and assistance from advocacy service, because the advocacy service have a better understanding, a better knowledge. They're doing cases. They can compare between claimant A, claimant B, they just had an award last week. Claimant B and claimant E is almost identical, yet they've been offered different things. So these are the sort of things that an advocate would be able to do on behalf of the claimant. But if the claimant have no knowledge, they will just accept the first offer that's been given to them because they don't know any different. Okay. Let me just bring 2 points before I open
Gary,
for questions.
Gary, just a quick interruption. Sorry. Remember, we've got 2 parts this today. We're gonna go into the speak about the Windrush.
Yeah, the other one. Yeah. So
what
I'm going to
questions
do,
and then sort of wrap up and move on to the second.
Yeah, what I'm going to do, I'm just going to give you this 2 points. Then I want some question on what's been said for this first element, and then we're going to talk about the second part is to do with a meeting with the Home Office. So if you're a minor and you've been supporting as a close family, supporting your mother, your auntie, your cousin, you know, any family member, but you're under the age of 18, you're considered to be a minor. You cannot submit a claim as close family claim. Somebody will have to submit for you, right? Because you are a minor. And what it says, if the claimant is under the age of 18 on the date their claim is made, the claim must be on behalf of the claimant by a person who has the parental responsibility for them. Okay, doesn't mean that they won't get a claim, but they cannot submit it themselves, okay? Because they're under the age of 18. And the other point I would like to make, for those who lack mental capacity, if the claimant lack mental capacity on the date their claim is made, the claim must be made if the claimant in the United Kingdom by a person exercising power of attorney over the claimant financial affair or by deputy guardian controller with power over the claimant financial affair. So again, it's stressing where there is lack of capacity, what the Home Office will be looking for is who has the power of attorney or the equivalent wording, because in some countries you don't use the exact words, but somebody who has the written authority to act on behalf of the person who has capacity issues. And it cannot be verbal, it has to be formalized, it has to be written. And here's a warning for many people. As your parents and grandparents get older, right, Alzheimer's and dementia may step in. It may start to affect their memory, affect who they are, don't even recognize who you are as a family. So, you know, when we start seeing early signs that a family member is experiencing these things, we should take some action. We should start to get the authority, get the necessary check and documentation done so that we are in a position to say, I have the legal responsibility for my uncle, my auntie, my sister, etc., etc. So I can then take the claim forward. Very important. It cannot be a verbal thing. You must have the written authority. So we've spoke about primary claimants and we spoke about close family claim. The deceased is no different from the primary, so that is exactly the same because the person was eligible, but they had passed. So another family member will submit the claim. Okay. Now, because I've been using the full guidance and there's more information and definition and interpretation and the various annex where you can find information, I'm encouraging other people to do the same. Make sure you have access to the full casework guidance. I'm not suggesting you read it all at once. I'm suggesting you get familiar with it, go back to it as a reference point, and keep reading it to get the understanding of what the caseworkers would be looking for when they receive your application for an award or a claim. So at this point, I will pause, and I want to know if there are any questions from the audience. Firstly, in relation to what we've said about primary claimant, and secondly, anything around close family claim, or any other question that you feel you need clarification on. Please, Caroline.
Hi, yeah, thank you. Sorry, excuse me. I just wanted to check to see if I've understood that. For example, my grandfather and my father are both deceased, so I can do a claim for both of them as a deceased claimant.
Yes.
My mother,
provided they're eligible, and to be eligible, we need to check when they actually are. The dates and where they came from.
Okay, so then, excuse me. So then, my mum, who's still alive, she can claim as a primary claimant herself.
Yes.
Providing she fits the criteria, of course.
Correct.
As children, and potentially 3 grandchildren, we can then apply as close family members if we were then impacted by it, rather than claiming as primary claimers. Is that what I've understood? Is that how I've understood it? To be
you've understood. But there's something else. I just want Roland to come in, because there's another point here, because we have had claims at primary as well as close family.
Right.
Okay.
So we as children could potentially claim both as primary claimers and
right. Yeah. Let me get a definitive answer here. So we've had this situation. Roland, would you mind just answering that question, please?
Yeah, good afternoon, Colin. Thanks,
good afternoon.
So let me be clear here, okay? So if you were directly impacted, for instance, let's say in your case, I'm not saying it's the case, let's say you went to apply for a British passport, and you were told your mother did not sort out her issues, she's still on indefinite leave to remain, etc., etc. And as a result of that, whatever excuse was given to you, you were told you can't get a British passport, or you were told, question at your job, you're not allowed to work here, had issues after you left the UK and returned. You were directly impacted. In such a situation, in that particular case, you would be eligible and possibly entitled to compensation as a primary claimant because you were directly impacted. You had your life disrupted or impacted due to your inability to prove you got a right to be in the UK, or your right to be in the UK was challenging. I'm paraphrasing somewhat, okay?
Yeah.
You would have a primary claim. Now, you mentioned your mother. If your mother was impacted, right, and it's established that she's entitled to compensation, then you'd have a second claim. You would submit a close family member claim against the deceased estate claim that would be submitted for your mother. Let's make that clear there. So don't shut down. Now, because you're making a close family member claim, do not shut down the option of making a primary claim, vice versa. You're making a close family member.
So you can still make a primary. So,
claim.
For example, we as children could, for example, and I'd say, and I'm just hypothesizing here, make a claim against both our parents as a close family member claim. if both our parents were impacted and therefore compensated.
So you could have a primary claim in your own right. You were impacted, and then you could have two close family members. One against your mother claim, one against your father on both sides, for both parents. And if along the way, after having those three claims, a primary and two close family member, you identify that one of your sister or brother was picked up and was threatened with deportation and couldn't work, etc., etc., he would submit his primary claim, and you also additionally put another close family member claim, and likewise he could put a close family member against your claim, a close family member claim against his mother, a close family member against your father, as long as the eligibility criteria
is met
and the entitlement criteria is met, so to speak. Now, just to touch on deceased estate claim, when it comes to the deceased estate claim, it's the next of kin or the executor of the estate that would make the application for the deceased estate. Then, if there's no will, then there's a process you have to go through with probate and so on and so forth. Not going to go into the details of that, but need to say the next of kin of the deceased individual or the executor of the estate. And if it needs to go through probate and the lawyers are going to be involved, etc., etc., to establish who has got the right to submit said deceased estate claim, then the Windrush Task Force or the Windrush Compensation Scheme will pay up to £1,500 to go through that legal process, so to speak.
So you have to have the administrative or probate paperwork in order to submit a deceased person's claim.
That needs to be established.
Example, could my mother not do it? Would she be able?
Is your mother still alive?
Yes.
Right. And you mean yes, she could submit her own primary claim, but is your father deceased?
Yes.
Right. I'm not a legal expert. I'm not, but from past experience, by default, if your father and mother were married, then that by default would go to your mother, and your mother would be the next of kin, so to speak.
Yeah, so she could submit a claim without the need for having probate, because there was never that process was never done.
From past experience, you would still need to go to do there's still documentation to fill out, because how the process works, you fill some documentation out, a different documentation from the compensation application. You'll have to build out that form, send it on to the Home Office, to the Windrush Task Force, and then they will go through that.
Go through. So there's a process
whether
that needs to be gone through.
Whether it needs to go through all the way through probate or not, then that will be decided by the Windrush Task Force. Okay. Let's say I'm no legal expert. I'm just
no, that's fair enough. That's
clearly
that's pretty clear.
A process that needs to go through, whether it's probate or whatever term going to be used, in order to establish definitively who has got the right to submit the deceased estate claim, and it's not some guy or some girl from a
it's just not anybody.
That's any old one. And you may have to have a discussion with your brothers, your sisters, etc., to decide who is going to do the lead in terms of the claim, who's that individual or individuals that's going to submit and deal with that deceased estate claim. And this is nothing to do with sharing up the money or sharing up whatever benefit you get. Okay, that's a discussion that you'll have to have. But there's a process when it comes to deceased estate claim. It's not that complicated.
But there's a process you have to go through. Okay, no, that's fine. One last question, and then my apologies for hogging it a bit. Would it be able to extend to grandchildren as well?
Right. When you say extend to grandchildren, I say grandchildren.
So would they be able to make claims?
Depends. I'm going to try to get some clarification here. Are you asking that the grandchildren will be able to represent the deceased estate claim, or be the next?
No, would they be able to claim in their own right if they were impacted?
As close family member.
Yes.
If they were impacted. Okay?
Yes.
If they were indirectly impacted. As remember, going back to the primary claimant, who can apply as a primary claimant? Garrett mentioned 1973. He mentioned 1989, where you came from, etc., etc. But let's not forget, if you entered the UK before you got to the age of 18 years old, and your parent or grandparent came from a Commonwealth country, you too can apply. But this particular group I'm going to mention now is often forgotten. You are born in the UK, and your parent or grandparent came from a Commonwealth country, you too can apply, because they're individuals that were born in the UK, and when it comes to them getting their British passport, they were told your mother did not do what they need to do in some cases, and grandma was on indefinite leave to remain since she came from Ghana, and your father was on indefinite leave, whatever documentation, didn't sort himself out. Consequently, you as a grandchild is not entitled to a British passport, and you lost your job, etc. In such a case, then that individual will be entitled to claim as a primary claimant. We got one primary individual, a particular individual, a popular vlogger, born in the UK, lived there, etc. Do all the usual. Lived in the UK, went to Jamaica in some sort of business there, was there for a number of months, was coming back with her documentation, degrees, or whatever. She needed those when she was in Jamaica. In case an opportunity presents herself there, she could say, here are my documentation, I went to university or whatever, I can do the job. On her return to the UK, landed in the UK, they saw her British passport. I'm British. She got all these documentation. In their head, the immigration officer's head, as we Jamaicans say, something or something all right. Consequently, she was delayed at the airport for 2 hours or more while they questioned her, despite the fact that she was born in the UK. Now, because her parent or grandparent came from a Commonwealth country, she can submit, or she can make a claim as a primary claimant.
Right.
Let's get back to your question about the grandchildren. And when it comes to close family member claim, and this is what Justice for Windrush Generation has been saying, as far as I know, I've not seen the guidance note for over a month now, but up until before a month ago, there's no category in the scheme for grandchildren. Okay, and Glenda Caesar isn't here. I think she's still in here. She probably can if I misspeak or anything, then she can pick me up. There's categories there for brothers, sisters, let's say, and children, but there's none for grandchildren, and that is why we are campaigning and lobbying. Says it makes sense that grandchildren should be there as well, and be able to claim just like children. Same criteria. Don't need to have supported the primary claimant or anything like that, because in many cases, the grandchildren, like in my own case, the grandchild and the grandchildren can be closer to the primary claimant than even the children. Because in some cases, the children may be that distraught or stressed out, that is the grandchildren, the 17, 18, 19-year-old that can pick up from where the 40-year-old child should have been doing and support the grandchild, the grandparent financially, etc., while they were stuck out in Sierra Leone, sending them money to MoneyGram and so on and so forth from the part-time job or whatever they're doing. So, as is, short answer to your question, as is at the moment, my understanding is grandchildren, children are not eligible and entitled to apply to the scheme as close family members.
Okay.
And Glenda Caesar is in here. Is Glenda still here?
Yeah, Glenda is still
Yes,
here.
yeah, I am here. I'm here, Roland.
Would you like to do any elaboration on that, Glenda, please?
Yeah, exactly what you said is correct. They haven't as yet added grandchildren, and I believe that they should do, because some grandchildren are looking after parents or relatives that have been affected by that. But at this precise moment, that is not being done. Can I just mention one more thing in regards to close family members? What we have found is that close family members who supported the primary claimant financially, they have to submit a living cost form. And what this scheme is asking for is detailed clarification to show how you supported this primary claimant financially. Another thing, what they don't want and what they are putting in place is that no two same family member can claim for the same cost. So one family member may have been assisting, let's just say hypothetically, with the rent or the mortgage, and another one was doing the shopping and the bills. They are very strict on that as well, what we've noted. I've challenged them on that and saying, look, they don't take it in turns. One may say, oh, I'll do the shopping this week, and the other one will say, well, I'll do it next week. But if you have it detailed and you can provide it on bank statement, especially, even if you were withdrawing from the cash point machine, it's good that you highlight that and submit that with your claim as a close family member for living costs.
Yes, yeah. And this is a good point. Thank you, Glenda, about evidence. And don't forget, there are things that the Home Office will require that is impossible to evidence, but there are things that you should be able to evidence when it comes to, sending money, paying for something, paying for electric, paying for phone. When it comes for paying things, right, they would expect to see some evidence, either through your bank statement or your phone bill, whatever. They expect to see something. And the other important thing that we always stress, that when you make a claim, for each of the claim that you make, at the end of the application, there is a declaration to be completed, and it asks you to read the declaration. And what you're saying, the information that you're submitting, to the best of your knowledge, is accurate. Now, we don't mean, the 1st of December, 1953. You may not remember the day in December. You may remember the month and the year. But as far as, as possible, you're confirming what you're submitting is truthful. Okay? And so, that should alert you that you have to think about what you're saying and what information you're putting down, because you'll be asked about this information. And if they come back and say, well, we need further evidence of this because you mentioned this, then that's the old point, for you to then produce the necessary information. So it's not just a matter of just saying things and you cannot substantiate and back it up. As far as you can, evidence is required. Has that been helpful, Caroline?
That's been really helpful. Really,
Okay.
really helpful.
Now,
Thank
just
you.
before we leave this section, and a very important point for everyone listening on the call today, Justice for Windrush Generation is working closely with other partner organizations, and in particular with an advocacy organization known as LAW, Liverpool Advocates for Windrush. Last Thursday, LAW launched its partnership with Liverpool John Moore University Law Clinic. We now have access to lawyers, not just on Windrush immigration, but also other aspects of law. So what we're now in a better position to offer more support to individual claimants. Even if your particular issue is not Windrush, the law clinic have got specialism in family law. They've got specialism in criminal law. They, a whole range of lawyers. It's the largest pro bono clinic in Europe. And so, what we'll be saying, we now have a place where you can get more help and support with Windrush and outside Windrush, because we are not the expert. We always said we're not immigration lawyers. We do not give immigration advice. We can signpost to where you can get advice. But the advice at the law clinic, there is no fee. It is a pro bono clinic. And I've put the information in the chat. LiverpoolAdvocatesForWindrush.org is the website. So you go there and you will find the information. And the law clinic operates in the university. So please, avail yourself of that information, and we can pick up other matters that is non-Windrush, as well as any complicated case that is Windrush. The clinic can deal with that. So that's a bit of information for you to share among yourself and let other people know about it. Reginald? Reginald, your hands up.
He's on mute.
Right.
You have to unmute.
Reginald, can you unmute? You raise your hand. Can you unmute, please? You know what's happened there. Okay, I'm going to leave that now. It's now 4:30. We've got about half an hour. What Roland and I would want to do now.
Quick question, Gary. Just a quick question. Sorry, Tim.
Yeah.
With the Justice Clinic in Liverpool.
Yeah.
Do they deal with data breach?
I don't think there are any law that they don't deal with. So the question is, we just have to ask.
Okay, fair enough. All right, back to you, sir.
Yeah. It's growing, so there are more law firms joining the clinic as part of the bigger partnership. And we now have a new lead day in Liverpool, who is now coming to the partnership with law. So we've got access to a number of law firms in the city, and it's growing. As I said, it's the largest pro bono law clinic in Europe. So it will get bigger and bigger, which will give us, access to more legal advice and help. What I'm going to do now is just to park the conversation around Windrush compensation scheme and status for a moment. And I want to just bring to your attention some new development that is now taking place. So you probably know that, or you probably have seen in the media, a very important meeting was held last week in London. And that meeting was held with the Home Office,
Hello?
the Home Secretary, the Right Honourable Yvette Cooper, MP. She brought the meeting together with a range of different organizations, specifically as a roundtable first conversation to discuss issues around Windrush. And where this is coming from is that you may recall that after the general election, the Prime Minister made a public statement. It went out on Twitter and it went out in different places. And what he said is that during this administration of the new government, they will be looking at how to reset Windrush. And that word reset is a word that we still don't know what it means.
You know that
Sorry, who's that? One moment. Let me just mute that. So, so last Thursday, a meeting took place that brought community organization who is operating in the Windrush field, those who are supporting claimant and those who are campaigning for change, like ourselves. We all came together, and the meeting was chaired by Home Secretary Yvette Cooper. And we were all able to contribute to that meeting. Prior to the meeting, the Home Secretary had sent out a document that asks specific question in relation to how Windrush can be improved. And one of the questions on the document that we all had to submit and respond to was about this new ambassador commissioner that is yet to be appointed, a public appointment that will take place shortly. And she wanted to know what the view was from the different organizations about this commissioner. And first of all, you can imagine that the first thing that we would want to know is, whether or not this commissioner will have any teeth. What clout will this commissioner have? So what will be the responsibility of this commissioner over the Windrush scheme, etc., etc. So they were asking specific questions. The appointment has not yet happened, but it's in the pipeline. It is a public appointment. So when it is when the person, he or she is appointed, the whole country will know. So it will not be a secret. It will be out in the public domain. As to what the role of the appointee, the commissioner, will be, we don't know. But in the meeting last week, there were things that we expressed that we would want the appointment to consider going forward if we're going to have a reset to Windrush. In other words, if Windrush is going to be fit for purpose or improve, then the commissioner will have a responsibility, how that will happen. And so this was the first set of meeting. We also expressed in that meeting, it should not be a one-off meeting of engaging with the organizations and with community reps. It should not be a one-off. It should happen on a regular basis. And we suggest that maybe they want to consider how frequent that should happen, bringing people together, on this subject matter. So that is for consideration. Whether it will be a quarterly thing or a 6 monthly thing, we don't know. Yet to be said. But the expression went in as to the view, how we think they can move forward by continuous engagement. And then we sort of went around answering specific questions that the Home Secretary raised in relation to the Windrush compensation scheme. And she was very particular because she wanted to know, and there was clearly in the room, people express that, it's the scheme should not be where it is. It should be, taken away, removed. That was expressed. However, what the Home Secretary response is that if we're going to make improvement to the scheme, she doesn't want a long delay of having to, to remove a scheme from one department to somewhere else. All that will take time, etc., and that will have another impact on the community and its claimant, and also will have an impact on how long people will have to be waiting to actually see some definite changes. So she was very, strong on that, because she wanted to see some changes more quickly rather than, down the road, how many years down the road. Now, that's a brief summary. I'm going to bring Roland in because both Roland and myself were present in the room. Roland was representing Justice for Windrush Generation. I was representing Liverpool Advocate for Law and Windrush. Each organization were given one place on this meeting. So we're able to at least utilize our space and to bring issues. We brought issues from a campaigning perspective, and we brought issues from the advocacy and the claiming perspective to the Home Secretary. Now, Roland, is there anything you want to add as to the conversation in the room on the day when we were asked various questions?
Yeah, can you hear me okay, Gary?
Yes.
Yes, what was mentioned in the room is speedy delivery of the scheme. No clarity was given as to the fine-tuning, expansion of the scheme, making the scheme fit for purpose. And when you say the scheme is not fit for purpose, one of the things that we're concerned about is the scheme itself. She was focused on speedy delivery of compensation. We are concerned about the amount of compensation, but that was not mentioned as far as I can remember. If it was mentioned, there was no clear definition given, and that is a major issue there. I am of the belief that the government will talk a lot around the scheme. They will talk about things like community cohesion, preventing it happening again. But I'm of the belief that we should focus on primarily those that have been impacted and are still being impacted, and ensure they get back in the position they would have been had they not been wronged by the Home Office. The scheme as it is at the moment, the way it's designed, etc., will not put them back in the position they would have been had they not been wronged by the Home Office. So the speedy delivery of the scheme is welcome, yes. However, the scheme needs to be looked at, and hopefully the Windrush Commission will be able to influence the decision maker has to fixing the scheme. The scheme needs to be fixed. So any discussion outside of revisiting the scheme, as far as I'm concerned, is a joke, and it itself is not fit for purpose. Regarding this session now, Gary, I know you're gonna have to go soon. If you need to go, I'm willing to hold the chat for the next couple of hours needs be, because this discussion we're gonna have is well needed and it's timely as well. So back to you, Gary, back to everyone else. I can go on for quite a while. Yeah. And if needs be, if Yuan is available or Mimi and I've got to go, then and the host over to them are Glenda Caesar.
Let me just bring Glenda in, and then I go to Reginald before I comment further on the roundtable. Glenda?
Thank you, Gary. Thank you, Roland. We, as a direct victim and part of a victim-led group, which was, like, I've got to say, one of the first groups that even approached the government, and the government that's in power now, before they took over, we had mentioned to them about the scheme and how it went. Nobody as a direct victim was invited to that round table, which was really upsetting, and I had to go. But previously, the day before this actual round table, myself, Desmond Jadu, and Clive Foster had met with the Minister, Seema Malhotra, and the Home Secretary was meant to attend, but she couldn't because she had to make a speech. I did bring it to her attention about we need to be represented. No disrespect to the organizations that were there, because obviously they work very closely. But it's better to hear from direct victims, because they know the trauma that they've been through. They were discussing about reconciliation events, which is something we discussed way back when, and the Tory government had taken it off of the agenda. But I did mention to her that we need not just third party, we need people who've been directly affected so they can actually say what they would like to be done. I also mentioned to her that any commissioner that's been put in place we should have access, as all the organizations should have access, to seeing what the job description is going to be, to see if this person will fully represent us and put over what we would like to see in place. I mean, even now, as victims, and you will see that there's some high profile stories out now, always around Black History Month, but they do discuss about how they feel and what they would like to see. So this is something that I've raised with her, and I raised with her when I was at the conference on Friday. So we're still pushing for that. We want the victims to have a voice as well. Like I said, no disrespect to the organizations, but what we're also finding is that there's no central point for people to even access the organizations. It's something else I mentioned at the conference, so that they know who to go to. And there's plenty of people coming forward that do not know about the organizations that are there to help them, the advocacy especially. So this is something that we would like, and this is something that we're going to push for. Yeah,
very good point. And in fact, Glenda, if you get any feedback of the roundtable on Thursday, you would know that in the room, with questions around the scheme and improving the scheme, and one particular point that I raised to Yvette was about the comparison between the post office Horizon scandal scheme payout and the Windrush scheme, and there's no equity in Windrush is always the one that is at the bottom and push off the grid, and I made that point quite clear. There need to be equity between the schemes, and that's a fair point and absolutely correct. And Roland and I, we've talked about victim led and the people that they should be talking to, and this is always the case. I don't know why, because they know people who are part of the victim. It always seems to be the case where the victim side is left out, and we have stressed that it is important. I would hope that out of that conversation, because we said it should not be a one-off conversation, I would hope that Seema and Yvette would start to think how we can engage with the wider victim of Windrush, rather than going through organizations, etc. And of course, that's always another issue in terms of organization. Who are they representing? In their capacity. And victim should be at the heart of everything for Windrush. Absolutely, 100% with that.
Thank you, Garrick. I much appreciated for the support for the people out there within your area as well. But we it's something that we have to keep on the agenda. I was told that there will be more meetings, and it will be more, according to them, victim focus. But we're hoping that we can all come together and we all sing from the same song. Let's make sure that is done. But thank you, Gary. I have to go. Very good meeting.
I'll be going myself in a minute. Yeah. Oh, thanks for that, Glenda. Thanks for your support.
You're welcome. Bye-bye.
Bye-bye. And the other thing is, as we said, this conversation should be continuing. Now, our next rally, so we're hoping now in January, that between now and January, that we will get some substance to some changes from the Home Office, and we're hoping to be able to to have something that is tangible coming out of the conversation that can be seen. That was the thing we said. We need to see the tangible evidence of change. You want to improve something, let's see how you're going to do it. We also talk about the length of time that people are waiting to get their claim through, and people are dying before they're getting their claim. That was emphasized over and over. So we have to now wait and see what action will come out of that conversation last week. Reginald? Reginald?
I think his device is a bit.
Hello.
Yeah, he's in now.
Yeah, yeah. Your
Hello.
question, please.
Afternoon, Garrick and Roland. I just want to ask a quick question because I think there's a group of people that are being forgotten in this scheme. I mean, you can't claim for compensation except you're eligible, isn't it?
Yes, you have to be eligible. Yes.
Yeah, exactly.
Yeah,
So
I agree with that.
I'm originally from Nigeria. Yeah? My dad settled in the UK prior to 1971, around 1969, and he was the United Kingdom. He settled here and became a citizen of the United Kingdom and colonies. Now, in 1975, because of the problems he faced, which is why I'm putting in a claim for him as a deceased representative, because he's deceased now. He renounced his CUKC citizenship in 1975 to acquire Nigerian citizenship so he could go back home.
Mm-hmm.
Now, what the Home Office is refusing to understand is that there's a law in the British Nationality Act 1971 that protects all CUKC citizens. And it says so. It says, through the existing act as then in force with respect to the right of abode in a deceased case, a CUKC who renounced that status in order to retain or acquire citizenship of another Commonwealth country have a residual claim under Section 21B of the 1971 Act as amended. I've been fighting with the Home Office since 2006. I came here when I was 28. I've been trying all as much as possible to get my status based on the fact that my dad was an original citizen of the United Kingdom and colonies from a Commonwealth country. I was able to resume his citizenship because his right of abode was protected. Even though he renounced his CUKC, his right of abode was still protected under the law. So when the law changed in 1981, British Nationality Act 1981, all CUKC citizens became British citizens, right? And I went ahead and applied for my dad's passport. It took about 2 years, but my dad was able to get his passport. So you can see there's a transition between a CUKC and a British citizen.
Yeah.
Right?
Okay.
And I've put in a claim. I put in a claim as a deceased estate. They wrote to me and said my dad was eligible, right? And then when it came to compensation, they said he wasn't eligible for any compensation. It's now in review 1. When it came to my own case, I put in my own claim as a primary claimant because I suffered the same untold hardship of proving my rights in this country for 8 years. I've been fighting this since 2006. I didn't get my right until 2014. I got my right of abode in 2014, and then I got my British passport in 2018. Now, they're forgetting the area of the Commonwealth countries that had such rights. In their statement to me, they said because I was born in Nigeria, I didn't arrive in the UK before I was 18, and an eligibility requirement of a child of a Commonwealth citizen is that you were under the age of 18 when you first arrived in the United Kingdom. But they have forgotten that my dad was a citizen of the United Kingdom and colonies who had the residual claim to the right of abode that was protected under the law. So you cannot treat him as a Commonwealth citizen on his own. You have to treat him as a British citizen as well.
Okay. Just pause there. Yeah, pause there for a moment. I really want to hear something. Now, Ewan, you might be smiling at this, right? Just listening to what Reginald is saying, right? I'm going to ask Ewan to come in and make some comment here. Ewan?
No problem.
Hi, Reginald.
Hi.
Yeah, so I met Reginald on Friday, and I was stood there talking to him and also a Home Office official from the nationality policy team in Liverpool. I think we were all in agreement.
That's correct.
His case has merit. And it's interesting because I have something that he needs to see. We'll probably discuss it. His case is very strong, but again, there's a there's a semblance of sort of a gatekeeping here where, even in the scheme, it says he would have had to arrive in the UK before 18. And I've already seen that.
Mm.
And that put me off straight
Yeah.
away because, as you know, my grandfather's case is similar to his. My case is similar to his.
Yeah.
And British citizens have children anywhere in the world, and those children are British. They have a right of abode, etc. And I know the specific areas of the law he's talking about. So again, the scheme is wholly inadequate, or, because it's built around those same laws that were designed to trample the citizenship rights of people who were not born in this country.
Yeah.
And I've seen this in other cases. If his father was actually born here, he would not get that treatment. But it doesn't
That's correct.
change the fact that naturalization, registration, and adoption is equal to birth in this country.
Mm.
So
Yep.
I've mentioned some of this to the minister on Friday. I'm following up with a letter because people are being excluded from the schemes unfairly. So
That's correct.
that's my input, and I will follow up with you, Reginald.
Yeah.
To get
And
better results.
that's why I sort of wanted you to comment on that, Ewan, because we are experiencing very similar, and I must say this, we seems to be Nigerian applicants seems to be experiencing a range of issues almost deliberately, and sometimes we can't even find out why. It's just the fact that the way that they're interpreting their situation. So I'm very interested in this case, and if you need the law clinic to get involved on this one, then let us do that.
Absolutely.
Sure, absolutely.
Roland, I have to leave now, but you're going to continue the conversation for those who want to stay online. It's almost 5 o'clock now.
No, 4 o'clock.
Yeah, 4 o'clock. Sorry, yeah. I got 2 o'clock in the house. One on the computer, and the other one is telling the long, hasn't put back yet. So it's 4 o'clock in the UK because the clock went back last night. So Roland, if you want to continue the conversation after 4 o'clock, you're welcome to do so. But I'm having to leave the conversation now. I've got some other things to do because I fly out to the UK tomorrow.
I've got a few things to do myself. We will continue on the next Sunday chat is going to be second Sunday of November. I'm not quite sure what date that is. That's probably going to be the 9th.
Yeah.
And then we'll do the same thing again. And we'll have a discussion around the changes that are promised by the Home Secretary, the Windrush Commissioner, etc., etc. So we'll have that opportunity again.
Yeah. I noticed I've got Clayton Miles just joined the call quite late in the day, but if there's something specific that a question that you want to raise, or you need to talk to any of us offline, please don't feel that you're not able to be heard. Is there any question that you'd like to raise, Clayton?
No, not at present. I just wanted to listen, to be honest.
Okay, that's fine. That's fine. Well, just for everyone, we have the justiceforwindrushgeneration.co.uk website where all the information as to contact, email, and phone number is on the website, and also information on the eligibility of the scheme, who can apply to the scheme, and each of the scheme there's information explaining primary claimant, close family, and deceased. It's all in one place on our website. So please, have a look at that. And if there are anything that you would like to follow up, then there's an email address and a WhatsApp number that you can reach us. So next week, we're going to be out of the UK. We're going to be in Jamaica, and we will be broadcasting from Jamaica on the next Sunday chat. So just to let you know that. So, Roland, are you going to give people a few more minutes, or you want to finish off now?
I'll probably keep it running. So if you've got any family members in Jamaica, we're going to be there and doing a few sessions there in Kingston, St. Thomas, and possibly in Manchester as well. One-to-one session, and hopefully we will bring the Home Office in community engagement team via Zoom. We intend to, what we're doing in Jamaica, we used to use as a template for other parts of the world, other parts of the Caribbean, and even possibly Nigeria and Ghana. So in Kingston, we're going to be at the Jamaica Library. In St. Thomas, we're hoping to be at the Alice Primary School. And in Manchester, we're not sure yet.
Yeah, we haven't fixed the date for Manchester, but certainly Kingston and St. Thomas. So, you know, social media is very powerful. So, you know, just tell people, you know, that we're going to be there, and we will certainly let, you know, let people know with Twitter and with social media what we're doing. But the most important thing is that you know how to contact us, and just visit the website, and all the information as how to contact us is there for any further follow-up information or support. It's there. So thank you very much for your attention this afternoon. And as I said, our next session will be on the second Sunday. Don't forget, we do it twice a month, the second and last Sunday of each month. Always the same time, always the same Zoom login. Second and last Sunday of each month is the Windrush Sunday chat. So thank you very much, and have a good afternoon. Until next time.
Everything goes out. Yeah. Anything in peace. We can't even get peace from the time.
Derek,
They got to us a parliament the other day.